This courtroom battle is about more than just one man. It's about the integrity of an entire election system. Prosecutors say Exekaya Rao's falsified election petitions, potentially undermining the democratic process itself. But Rouse insists he never meant to cause harm and is now pleading for mercy. The judge, however, isn't convinced. With a long criminal record, accusations against the court, and a federal lawsuit hanging in the air, tensions are already high before sentencing even begins. So the big question is this a case of a repeat offender finally facing consequences, or a man who deserves a second chance? Let's break down what happened inside this intense courtroom.
The state of Ohio, we are here for sentencing preliminarily, and that I also know that there was a federal lawsuit that you have filed against the court as other members that are present in this courtroom. Despite all of that, it's my intention to proceed with sentencing. Some of the accusations that you have raised in this, in your letters to the court, in your appeal, and in your federal lawsuit are to me outrageous, but that's your position, and that the court intends to proceed with sentencing today. So with all of that, Ms. Tranter, is there anything from the state?
Yes, Your Honor, just very briefly. From the state's perspective, Your Honor, this case is all about punishment. This is not a rehabilitation case. The actions and convictions that we're here on today represent an attack on our electoral.
Right away, the prosecution makes their position crystal clear. This is not about rehabilitation. According to the state, this case is purely about punishment. The prosecutor argues that falsifying election petitions is essentially an attack on the democratic process itself. In legal terms, that's huge. Courts treat election integrity cases very seriously because they affect public trust in the system. On top of that, the state points to Rouse's extensive criminal history, including past convictions involving fraud and forgery. When a defendant has repeated similar offenses across multiple states, judges often consider them a high risk for rehabilitation. So the prosecution's strategy here is obvious: convince the judge that prison, not probation, is the only option.
Process, which is the very foundation of our government. This court, Your Honor, has a duty to protect that interest and the integrity of our election process. Additionally, the defendant has, as the court knows, an extensive criminal record littered with behavior very similar to what we have seen in this particular case: forgeries, prescription falsifications, receiving stolen properties. I count at least 5 separate times this defendant has been to prison. Either an initial sentence, and there's a couple of times here, as the court can see, that he has been judicially released, for lack of a better word, onto probation. Multiple times that probation has been revoked and he has been sent back to prison or sent back to jail. He has in no way demonstrated that he has any intention of complying with any sort of community control should the court choose to go that way. And frankly, I think he would just be a problem for probation. You can't treat and help someone who doesn't recognize that they have done wrong. And it's been clear from Mr. Rouse's actions that he accepts no responsibility in this whatsoever. As the court is aware, we sat through this trial. He was convicted on 4 separate petitions that were submitted to the Board of Elections, falsified petitions. So for that, I'm asking the court to issue a 2-year sentence on each of those petitions, representing the victims that occurred throughout those 4 petitions, for a total of 8 years in the Department of Corrections.
Thank you. Anything from probation, Ms. Sokobeki?
Nothing further.
As far as by what the state said about the election process needs to be, secure, I do agree with that. The election process should definitely be secure, and I wouldn't say anything against that. But I did want to offer my apologies to you and to whoever else for thinking that you were the one who was saying that, when it's clear that now that you weren't. There are some things that I'm going to have to do. I do believe I did file something to remove the other 12th Circuit thing that I had once I kind of realized it wasn't you doing all of that. And as Ms. Trainer has said, like I said, I've been in trouble a lot as a child. But as Mr. Gibbs just said, for about the last at least 10 years, 8 to 10 years, I came here to Ohio to do right. And I haven't been in any trouble since I've been in Ohio. Everything has been from California or New Mexico. I haven't been in any trouble since I've been here. So I just hate that I even went through all of this, to hate that anybody even got affected by this stuff. And it just sucks. I wish I hadn't did all that stuff. And, I mean, that's even know anything that happened. So I feel like I do owe them something.
This moment is interesting because the judge partially disagrees with the prosecution. The state argues that the individuals whose names were forged are direct victims, but the judge frames it differently. Instead, he says the real victims are the citizens of Ohio, because election fraud damages public confidence in the system. That distinction actually matters in sentencing philosophy. Courts sometimes broaden the definition of harm when crimes affect institutions like elections, financial systems, or public safety. But at the same time, Rouse is now shifting his tone dramatically. Instead of denying everything like earlier in the trial, he's acknowledging wrongdoing and even suggesting he should compensate the people who had to testify. The big question now becomes, is this genuine remorse, or simply a last-minute attempt to soften the sentence?
Well, let me just, I'm going to give you another chance to respond, but let me just tell you, I don't agree with the state. I don't agree that these individuals are victims in the sense like we had the thefts earlier that you sat through. Those people that had something stolen from them, they're victims. I don't consider these people that testified that their name was forged on a ballot initiative petition. I don't consider them victims. However, I do consider the people of the state of Ohio, the citizens who vote on these initiative petitions on the ballot.
I missed their job. I was planning on going home this summer to get married, get my lawsuit, go home, get married, grab a few trucks, start a trucking company. Doesn't look like that's an option at this moment because of what I've done. So literally, I still think, that, maybe I still probably should have to pay those people for not being able to go to work and having to take away from their loved ones and their family to come here and, testify at court for something that they don't even know anything about. So, like I said, it's just shameful, shameful. It's embarrassing too, because like I walk in here, I was working with Mr. Ernst's office. I walk in here, we'd be helping people with what they were going through, and I watched the clerks and the same people, the sheriffs and everyone just looking at me like, man, like, what's going on? And so I just regret it all. I really do. I don't. And then when you told me on, the last bail hearing, when you just said, I don't think you realize the seriousness. So I sat back and I thought about that. And I really did. And it is a problem if someone does those sorts of things of falsifying elections. It's a problem because, I'm not even asking for leniency. I'm asking for mercy. Like, I really need mercy here because I have had it hard, but a lot of people have had it hard. So I don't believe that I'm a loss to society at all. Time now to get it all out. And again, like I apologize again. Like I said, I really thought that you. It sounds stupid now, but I really thought that you were the one making the sheriffs treat me like that. I really did. And I apologize for that because, as I see now, that's not what happened. Again, I would listen to probation. Don't agree that I'm not. So much for that, but like it's a shame upon him. Even 50 days. listening to the stupid conversations that people have. For a person that's been educated, a person that knows better, it's dumb for me to sit. It isn't even stimulating. It's just sitting in there and wasting away. I could be out here doing community service, giving back to the community. I could be out here paying these people back. That's about all I have, Your Honor.
Oh, finally. Starting to grow mushrooms out my ass.
Okay.
Now the judge begins addressing something that clearly frustrated the court throughout this case. The accusations Rouse made against the judge himself. Filing lawsuits against judges isn't unheard of, but it's extremely rare for those claims to hold up unless there's clear misconduct. Here, the judge directly refutes those allegations, explaining that he never contacted jurors outside the courtroom and never interfered with the sheriff's department regarding the defendant. What's fascinating is that the judge also acknowledges Rouse's intelligentsia, contrasts it with a long record of fraud-related crimes across multiple states. In sentencing hearings, this kind of statement often signals that the judge believes the defendant has the ability to change, but hasn't taken responsibility for doing so.
Thank you, Mr. Rouse. I will say, you come across as very intelligent. Your record, your prior record, is horrible from multiple states. Same type of offenses, forgeries, thefts, things like that, from multiple states. You have 2 outstanding warrants from California, which apparently they're not that concerned to come out here and pick you up. But that being said, the court believes that from the beginning of this case, from the first time that we met, that I had treated you with dignity and respect. And I get repaid with that by accusations of being a racist from you, that people in this county are racist, which I dispute because I have sat through almost 100 jury trials, and I do have black Americans that come in here and are defendants that juries, all white jurors, have found them not guilty because they follow the law, which is what I always intended to do. To say that you were always compliant with the pretrial supervision is not accurate, because one of the conditions of your bond was what? That you not smoke THC. I recognize that you have a medical marijuana card, I explained to you early on, I never enforced that, I never revoked your bond, I never threatened to revoke your bond with regard to that, but yet you've named that as one of your grounds in suing me as a violation of your rights. But you continued to do it despite my telling you you didn't. But now you've been diagnosed with severe cannabis use disorder. And what you fail to recognize is that the THC content in today's marijuana is so significantly high that it is affecting both your mental health and your physical health. But people don't want to recognize that because it's just something I've done since you were, 14 years old. You've smoked marijuana daily, and you don't want to stop doing it. So that's one thing. But you've also been diagnosed with some other mental health issues. So moving forward, knowing your position with regard to just that issue, when you have severe cannabis use disorder and a significant mental health disorder, marijuana is making it worse. And you've heard me. You sat through a couple sentencing, and I don't allow it because I've done the research and I know the significant mental health issues that it causes people that use it on a daily basis. And for people to say, well, I've used it since I was 14. I've had one of my veterans that stopped using it. He used it every day since he was 16, and he's now 40-something. So he stopped using it because he realized that I was right. He stopped using it. He gave it a chance. And he's like, well, yeah, I get it now. But some of your accusations, I think one of the accusations you leveled against the court was that I coerced some of the jurors into signing the verdict form. I have no idea where you got that because my contact with the jury is the same as yours. The only time I ever had contact with the jury was when I was sitting here and they're sitting over there, and you were sitting there. I never have contact with jurors back there. I never once reached out to the sheriff's office. As far as you appearing here in a wheelchair, you didn't during the trial in January. In fact, for the prior year, while your case was pending, you never appeared. I knew you had a medical marijuana card, but you never appeared to be disabled or injured in any way. I was told the morning of the trial that you had recently had gallbladder surgery. You had your gallbladder removed. You asked for some dispensation for that. I think Mr. Gibbs inquired about you standing because your incision was uncomfortable. I said, sure, no problem. I complied. You had to use the bathroom? I said, sure, you can use the bathroom. I didn't stop the proceeding every time you used the bathroom, and Mr. Gibbs waived your appearance because we wanted to keep things moving. But you consented to that. But yet you turn around and try to make it like I've done something against you personally, even to the extent of accusing me of telling the sheriff stuff. I don't tell Sheriff Riley how to run his jail, and he doesn't tell me how to run my courtroom. I have never once communicated with Sheriff Riley about you personally or your case. It's never happened. So it's kind of disheartening for you. Again, Mr. Rouse, I think you can be a productive member of society, but I keep coming back to it. There's something missing here.
At this stage, the judge shifts the discussion toward two major factors courts use during sentencing: seriousness of the offense and likelihood of reoffending, also known as recidivism. Election fraud isn't always treated like violent crime, but when someone has a repeated pattern of deception, especially involving forged documents, it becomes much more serious in the eyes of the court. The judge also touches on mental health issues and substance use, suggesting that heavy marijuana use may be affecting Rouse's decision-making. Whether viewers agree with that reasoning or not, it's clear the court is building a broader picture of the defendant's behavior over time. And that background often becomes the deciding factor in whether someone receives probation or prison.
And again, part of the purposes and principles of sentencing is punishment. And as Ms. Tranter said, and what I said earlier about the victim in this case is not the 4 people that came in and testified that their names were forged on this petition. They're not out anything. It's the citizens of the state of Ohio that are the victims in this case. So, is there something you wanted to say again?
Yeah, just again, like I said, I apologize, and a lot of the stuff was a blur. I was on Oxycontin and promethazine during the trial. So a lot of
But you understand, sir, that I was never made aware of that. You never made me aware of that. So I was not aware to sit there and say that I forced you to go to trial where you were on these medications. I didn't know about it. I knew you had surgery. My wife had gallbladder surgery. And trust me when I say my wife had gallbladder surgery about 3 years ago. And within 3 days of that surgery, she was hosting a graduation party for her granddaughter with about 200 people there. So, I know about gallbladder surgery because my wife had it. So I know she had her gallbladder removed 3 years ago, but she hosted a party with 3 days after the surgery. And she wasn't. And again, I know people react differently to surgeries, but that's my frame of reference. And if there was some request for continuance that you had made or further dispensations by the court, I would have considered them, but, I can't do what I don't know. All right. I have considered the purposes and principles of sentencing, the relevant seriousness and recidivism factors. I know the state disagrees with me on this, but I am going to make a finding today that the 24 counts 13 through 24 are allied offenses of similar import and that they merge with the counts of the election fraud. Does the state have a preference as to which counts we proceed on, 1 through 12 or 13 through 24?
State would elect to proceed on the election falsification 1 through 12.
So counts 1 through 12.
Yes, correct.
All right. So with that, the court is going to order you to serve 12 months in prison on count 1. And on counts 2 through 12, the court's going to order you to serve 12 months in prison on each of those, to be served concurrent with count 1. You have 52 days jail time credit, and you're indigent for the purpose of any fines, costs, or other financial sanctions. I recognize that this is a low-level felonies, but the court does find, based upon the type of offense in your prior record, that probation would not adequately punish you. The prison is necessary due to your extensive criminal history of similar conduct, and you have failed to respond to previous community control or supervision sanctions. Now, you're also subject to a discretionary period of post-release control. which means that upon your release, the adult parole authority may supervise you for up to 2 years. If you violate that supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time you get sentenced to. The court does find that he's indigent for the purpose of any fines, costs, or other financial sanctions. Ms. Tranter, is there anything else?
No, sir.
Mr. Gibbs?
Nothing further, Your Honor.
And with that, the judge delivers the final decision. Instead of the 8-tier sentence requested by prosecutors, the court orders 12 months in prison, with multiple counts served concurrently. That means Rouse will serve roughly 1 year behind bars, followed by the possibility of up to 2 years of post-release supervision. The judge acknowledges the crimes were low-level felonies, but ultimately decides that probation wouldn't be enough given Rouse's extensive criminal history and previous failures under community supervision. Cases like this highlight the delicate balance courts face punishing wrongdoing while still leaving room for rehabilitation. So, what do you think about this ruling? Was the sentence fair, or too lenient considering the allegations of election fraud? If you found this case as shocking as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.